Hi, I'm Jennifer Brown, editor of Canadian Lawyer In-House Magazine, and here with me today are Aaron Kempf and Karsten Lee of Weirfolds LLP. In this edition of the Weirfolds Quiz, we're talking about obligations around negotiating commercial leases. Karsten, is a landlord required to tell a prospective tenant whether they've had previous offers on the property and to disclose the details of those offers? For example, if they had received an offer that was only 6 months ago, or if the offer was $10 a square foot when really what the landlord is seeking is $30 a square foot.
So in the past, there generally has not been a duty to negotiate in good faith. So what that meant was landlords typically do not have to tell prospective tenants of any of its previous offers, if any, on particular premises. However, there's been a recent case given under the Ontario Superior Court. The case name is SCM Insurance Services and Medicis Corporate Health LP. Now, in that case, the court implied that there may be a duty to negotiate in good faith in certain circumstances. So the particular facts of that case was that one party, CIRA, had a restrictive covenant against the other party, Medicis. CIRA agreed to waive that restrictive covenant in exchange for the right to negotiate for the purchase of one of the businesses that Medicis was purchasing. Ultimately, CIRA and Medicis couldn't come to an agreement on the purchase price, and Medicis actually sold the business to one of CIRA's competitors. In the case, the court found that there may be a duty to negotiate in good faith because it was a necessary corollary that CIRA's waiver of its restrictive covenant gave it the right to purchase the business from Medicis. The court found that the parties must have intended that CIRA has the right to purchase this business in exchange for its waivers of the restrictive covenant it held. So the question is whether or not this duty to negotiate in good faith can be transferred over to the leasing context. One thing that we have to remember is that the finding of the implied duty to negotiate in good faith seemed to turn on the facts within that case. So going back to your question, it still remains to be seen whether or not an overarching duty to negotiate in good faith will be transferred over to the leasing context, and specifically whether or not the landlord has the duty to advise prospective tenants of any of its previous offers, if any, on any particular premises.
And Aaron, outside of a strictly leasing context, are there instances where parties are required to negotiate a contract in good faith?
Yes, there have been specific special circumstances where a duty to negotiate in good faith has been found. Those include things like employment contracts, relationships between franchisees and franchisors, relationships between insureds and their insurers, fiduciary relationships, classic tendering situations, and some specific circumstances surrounding requests for proposals.
Okay, thanks, Aaron. For more on this and other issues related to negotiating in good faith, please see the February issue of Canadian Lawyer In-House.